talk a little bit about what we do, and then Carol's going to talk
So,
about
un poquito de lo que hacemos.
housing court cases.
And I'll talk about the nuts and bolts of housing court cases. And field questions when we're finished.
Si tiene alguna pregunta cuando terminemos.
This is for my disability while I'm back here.
Okay. Well, I guess raise your hand if you can't hear.
That's what I was trying to do earlier.
So Housing Court Answers runs information tables in all of the city's housing courts, the 5 borough courts, plus the Harlem Community Justice Center over here. We also have an information table at Broadway to help night shift tenants, at 851 Grand Concourse to help night shift tenants in the Bronx. Just show of hands, how many people are Manhattan tenants here? And Bronx? Brooklyn? Queens? Staten Island? I left something out, but if you didn't raise your hand before. Alright, so mostly Manhattan. And mostly in this neighborhood? Yes?
Should be brought down the laptop bag.
So if you do go to Housing Court, you'll be in the Harlem, most of you would be in the Harlem Community Justice Center, which is if you live in 35 or 37 zip codes, or you'll be downtown at 111 Center Street. How many people here have been to Housing Court before?
Are you kidding?
How many people had a good experience in Housing Court? Ah, there you go, 2 people. All right. So at our information tables, we have lay advocates. They're not lawyers, and we provide legal information to people without lawyers. So if you're a tenant or a landlord without a lawyer, and you have a question about housing court, a housing court procedure, or what forms are available, or how to fill out the forms, all those kinds of questions that people have when they get into housing court, we can answer those questions. We can't give legal advice, meaning we can't tell you, this is what you should tell the judge about X situation. We can tell you, you're in a non-payment case, this is what a non-payment case is, this is going to be the next step in your case, this is what you should be looking for, and we give out these books for people who are in non-payment cases, and we walk people through the process that they're going to be going through in a non-payment case. So those of you who raised your hands before, and you said you've been in housing court, how many people were in housing court on a non-payment case? And how many people did get repairs? And then others, holdovers? Anybody been in holdover?
If you don't know, that's a good thing.
Right, right. So most 90% of the cases in housing court are non-payment cases. Most tenants who end up in housing court are there because the landlord is suing them for rent. And we provide assistance at our information tables by explaining to people what stage they're at, the next steps, what they need to do in the next steps. Again, not legal advice like what you say to the judge or what you write in your papers, but more like you have to come back to court on June 26th because we have a hearing at 9:30 and you will be doing, this is what will happen when you come back to court. So we give information like that. We also help people figure out whether they can get assistance with their back rent or get assistance with a lawyer or get some other kind of assistance to prevent eviction. So we do referrals and applications to the other programs. My staff and all of the courts are very knowledgeable about every program that's available in the city to tenants facing eviction. So particularly people who are in non-payment cases who are behind on the rent. So if you're on public assistance and you need to apply for a program called FEPS, or you're working and you're behind and you need $1,000 to help pay your back rent, we can refer you or do an application to a charity for that. So we do that kind of work at our information tables. We also have a telephone hotline. We staff it Tuesdays, Wednesdays, and Thursdays, 9 to 5, and you can call and ask a question. We can look up to see if you have a case that's scheduled. We can also tell you where to get assistance with back rent, or if you need to apply for legal assistance. And so we do all that. All that information is on the back, the third to last page of our phone numbers and how to reach us. This booklet that I gave to most of you, and I have more up here, they're in English and Spanish. We have them in English, Spanish, and Chinese. They talk about how to settle a non-payment case. That's the best way that you can possibly settle. We walk you through the process of negotiating in housing court, what to get into your stipulation, your settlement agreement, what's important to bring up, what's important to bring with you when you go to court, and what happens if you can't pay the rent, and what happens if your landlord's not making the repairs in your property. So that this booklet really walks people through in very simple language that process. The other two things that we do at our information tables are we help people fill out the papers to do an HB action, which is if you want to sue the landlord to get repairs. And we also help people, which doesn't come up very often, but just so you know, if you have a roommate and you need to evict the roommate, we help people fill out those papers and talk to them about the requirements of service and how to go through that process. Once again, we help anyone without a lawyer. It doesn't matter whether they're a landlord or a tenant. 98% of the people we help are tenants who are facing eviction for not paying their rent. The rest of the people, and most of the other people we help are tenants who can't get repairs in their apartment. So if you need help, go to our information tables or call our hotline. That's my
Okay, I am going to discuss the three types of cases that you will see in housing court. The first type of case is called a non-payment case. And what a non-payment case is a case where the landlord will claim that a tenant is not paying rent that's due. And we'll start with how the case begins, and then we can discuss various ways you're sued for non-payment by your landlord. Are there any owners here, or are we all tenants today? We're all tenants today? Okay, so I don't have to explain it all.
So when you're trying to say, like an example, I keep getting a bill that they say that I owe $10,000.
Let's save all questions to the very end if we do our presentations here. We'll be happy to take all the time you want. Okay, so the way a non-payment case begins, by law, first the landlord has to demand the rent. What demand the rent means is not that the landlord says, hey, Jane, you owe me $4,000, I want you to pay it. It's very specific as to how the rent has to be paid. Since most residential leases have a paragraph in them that says all notices in writing have to be, all notices between the landlord and the tenant have to be in writing to each other. Most landlords use something called a written rent agreement. And I apologize, I was supposed to do a handout for today, and I didn't. Reasons that are beyond control. But at the end, I will prepare a little sheet for Colin. If you contact Colin sometime next week, you can get a written So the written rent demand will be usually a single sheet of paper. We either say rent demand, 5-day notice, or 10-day notice on the top of the paper. The reason why you see differences is because the law says that the rent has to be demanded at least 3 days before the tenant is brought to court to be sued for not making the rent. But most leases have provisions in them that provide for the 5 or 10-day notice periods for the rent demand. So most landlords nowadays usually opt for the 5-day or the 10-day notice so that they're covered both under the law and under the lease. Because the landlord, when they make the demand, they have to comply both with what the law says they should do and what the lease says they should do. And sometimes your lease will have provisions in the lease that require the landlord to do certain things beyond what's legally required, though these are things that would totally escape 99% of the people who leases, so you don't get it. So once you get and the rent demand will say, if you owe us this much money, And it can't just be one blank number, one big number. They have to break down by month the demand. You owe us $750 for March, $750 for April, $750 for May, $750 for June. That's the way it has to be laid out. The rent demand has to be served. By service, we mean they can't just mail you a copy. That a process server has to come and attempt to serve you. The process server needs to try to find you personally. The process server comes to your apartment and doesn't find you. The process server has to come back at least one other time and find you. If the process server comes to your apartment and finds you and hands you a copy of that rent demand, and that is legally proper service. Now, if the process server comes to your apartment and finds somebody who either lives or works in your apartment and hands that person the payment, and that person has to be above a certain age, so the actual age is not set in law, and there's a lot of case law about 14, 15, and 16-year-olds and whether or not they were the appropriate person to hand the document. But that's lawyers playing games. You don't have to worry about that. They can hand it, so say you're a significant other, your spouse is home, but you're the main tenant. Hi, is Jane home? No, Jane's not home. I'm John, I'm her boyfriend, her husband. Oh, can you give this to her? What if you had a babysitter and the process server handed it to the babysitter? Not good service. Case dismissed. I've had a case dismissed on that. Okay? So the process server is supposed to ask, do you live here? The person says, yeah, I live here. Please give this to her. That's good service. If the process server then does two things, either that day or the very next day, which is, if you serve it on the actual tenant, that's good service. You don't, as a landlord, you don't have to do more. If you serve it on another person, okay? Serve it on another person, then the landlord has to do two mailings. One mailing to the tenant by certified mail, and one mailing to the tenant by first-class mail. Within 1 day, having handed it to the person. If after 2 attempts, the process server doesn't find the tenant at home or any other person at home who's capable of accepting the papers, then, and only then, can the process server get a copy of the rent demand and take it to the door, and then also do the 2 mailings within 1 day and take it to the door. 2 process serving attempts have to be done, one during what's known as regular business hours, which is usually considered 8 a.m. to 6 p.m. Monday through Friday, and 8 a.m. to 6 p.m. Monday through Friday, or non-business hours. This part is not written. I'm not going to find this part in the book. This part comes about in a lot of cases that got litigated, what is known as case law. That courts write decisions after the parties litigate cases, and courts make up rules. And the attempt during non-business hours has to be done on Monday through Friday, either between 6 a.m. and 8 a.m., between 6 p.m. and 10 p.m., and on Saturdays between 6 a.m. and 6 p.m. If the rent demand says, if you don't pay this money in 3, 5, or 10 days, you must either leave the apartment or the landlord will sue you. In 28 years of practicing law, I've only met one person who actually left her apartment. No, it was sad, and it was very sad because to get her back in the apartment required jumping through a million hoops. You don't have to move. Well, all these rules date back to like really legitimate medieval times. And that's a different lecture I give to lawyers on occasion. It's too arcane for today's purposes. But I'm going to give you one tidbit that you will not know. Until the 1920s, all leases in New York City expired on April 30th. You can look this up. You look up the archives, look online, do a Google search, you'll find articles on this. May 1st was known as movie day. On May 1st of every year, the streets of New York, this is before cars and trucks, the streets of New York City, every horse car, for like a 50-mile radius, was hired for people. The streets of New York City were full of horse carts, full of furniture, everybody's moving up. May 1st was movie. Now, going back to current times, so, the landlord has served you a rent bill. What do you do next? You don't do nothing. You wait until the landlord does something. If you haven't paid the rent after the demand, then the landlord can proceed and sue you in housing court. In order to sue you in housing court, the landlord has to have the process server serve you in the same way that I just described for the rent demand, with a different document. The next document is called a petition and notice of petition. Petition, it will say on the paper petition. Can we turn this on and write on it? The whiteboard? That's just slides. We don't have a whiteboard here.
No.
Next dollars don't look that much. Okay. A petition, P-E-T-I-P-I-O-N.
Or, you said, or?
It's called notice of petition and petition. It's two documents that come together. It's usually 2 pages stapled together. That document will have the information from the rent demand, plus some additional information about the landlord, a claim that you are a tenant, a claim that there is a lease in effect, a claim that your rent is a certain amount each month, a claim that that rent is the legal rent, and a claim that you owe a total amount due, and a breakdown of each month that is due. There will also be an allegation in there, if you live in a building in New York City with 3 or more units, that the building is a multiple dwelling, and the multiple dwelling is currently registered. That's the basic information you'll see on the non-payment petition. The non-payment petition will also have language in fine print that will tell you, go to your local courthouse to file an answer. Okay? That is crucial. Go to court, file that answer. Later we'll talk about what happens if you don't go to court. Okay? So here in New York County, Manhattan is known as, let's say, Civil Court of the Civil in the City of New York, County of New York. Manhattan is New York County. Queens County, Brooklyn is Kings County, Staten Island is Richmond County, and the Bronx is Bronx County. So it'll tell you to go to the courthouse at 111 Center Street, and the clerk's office at 111 Center Street is on the 2nd floor, 225.
I know it.
You wait on a line with your petition, and when you get to a certain window, there is a clerk. The clerk will hand you a document called an answer. And what an answer is a formal legal response to the landlord's written claims in the petition. Okay, and I'm going to go through the major defenses, which are the ones that are contained in the answer that will get handed by the clerk, because those are the most important. The first defense you'll see on that answer is something called general denial.
Sorry, I have a pen. Thank you.
You should always check that. If you check general denial, it automatically means that you contest, you disagree with everything the landlord says in that petition. That means that at the end, if you can't settle your case, go to trial, you've got to put, the landlord is forced to prove everything they say in that petition. If they don't prove a lot of those things, the judge could possibly dismiss the case. We don't want to get to a trial. So, always check the general amount. The second defense that you'll see listed there is, I was not served properly with the paper. Of course, 99% of the people who've shown up in court have no idea what proper or improper service is. So they will check or not check it depending on what mood the clerk is in, who gave them the form, and tells them whether or not they should check it. Agree? That's usually, you know, some clerks say, I'll check everything, and other clerks actually talk to the person and say, well, you know, you should check this one and not that one.
Well, actually, the clerks check it all.
They do it, then the clerks actually do check it.
So the tenant, the clerk will sometimes say, why did you pay the rent? Yeah, and you should go in there and say all these, every single defense. But the clerk, I mean, you can do a written answer, but generally, you're not doing your own written answer. You can do it on the court's DIY, do it yourself computer program, but if you're not doing your own answer, your own written answer, then you'll have to go and tell the clerk what your defenses are. And the clerk will write it down and then give you the form back.
Next page of defense is, I do not owe the amount the landlord is suing. You're contesting the landlord's claim. Very often, landlords are suing the rent that is not due.
That's pretty.
A lot of different.
Yeah, thank you.
So, you disagree, like what? They didn't receive your check, or they misapplied it, or the landlord is charging you an improper rent. You're putting charges in your rent that are not they should have owed, and they should have included in the rent. There's a million different possible disputes over the amount due. So, if you disagree with the amount due, that's the defense you should raise. The next major defense is, I have conditions in my apartment that need repair. And if in fact you do have anything in your apartment that needs to be repaired, this is the time to do it. Jenny, do they hand out the inspection request forms when you
No.
answer? When do they do that?
They don't do it at all. So if you want an inspection, you either have to ask the clerk, you know to ask the clerk, and 9 times out of 10, the clerk will say you'll have to tell the judge on your first appearance on the phone.
So that's important, though, that you tell them that you repairs. So that's there, it's in the record. The other defense that's on that answer that they hand out is that the rent is an illegal rent. If you live in a rent-stabilized or rent-controlled apartment, your rent is set by law. It has to be calculated a certain way. And there are often disputes over what your legal rent should be. We take answers and questions at the end, okay? So we'll answer all the questions. So that's, let's save that from the end, because that can be a little technical, and usually best to explain that in the context of people's individual questions rather than give a whole lecture on that. So that's, those are the basic defenses.
Yeah, so there's a new one, which is harassment.
Okay, harassment is complicated.
But it's on there, it's on the form.
Harassment is like subjective. It's like there was once a case back in the 60s. The United States Supreme Court was supposed to decide whether or not a film was pornography or not. And justices of the U.S. Supreme Court had to sit in a room and watch a porn film. And so at the end, you know, they asked one of the judges, you know, how do you describe pornography? And he said, you know, I can't describe it, but I know it when I see it. So harassment is the same thing. We know it when we see it, but it's part. Everybody will come up. If I ask everyone in this room, what is harassment? You will describe a different level of activity than the next person. It's very, very difficult to describe. The harassment under the law is a very specific set of circumstances they put in the law. The problem is, if you claim a harassment claim in housing court, and if you prove it, and if you win, and if the judge is inclined, all they can do under that law is put a violation against the landlord. So personally, when people come to me and say, blah, 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 harassment, I want to bring a harassment case, and they want to even pay me to bring a harassment case, I say, I'm not going to take your money. You're wasting your time. Because at the end of the day, all you will get is a violation placed against the landlord for harassment. I know. What's the fine? $750?
Yeah, but it is a defense.
It's a defense, though.
In a non-payment.
It's a defense, though. Now, when we get to holdovers,
Theory, yes.
when we get to holdovers, there's an important defense called retaliatory eviction, which is more of what people consider harassment. It's a very powerful defense in holdover cases. So that's what happens at the beginning of a non-payment case. So you will answer, you will give these issues, you'll give this information to the clerk. The clerk will fill out that form. It's a three-part form. One part goes in the court file. One part gets handed back to you, and one part is going to be mailed to the attorney or the landlord. The clerk will then assign a court date to your case, and that court date is usually 10 days or so later.
A week. Yeah.
A week to 8 days. 8 days. Usually 8 days.
Like, so if you go in on a Tuesday, you'll come back the following Tuesday or Wednesday.
Yeah, usually 7 or 8 days. So they'll give you a court date to come back 7 or 8 days later. There's a trick you should know. There's a morning calendar and there is an afternoon calendar. Monday through Thursday. If there is no afternoon calendar on Friday. So if you've received a non-payment petition and you don't want to be there in the afternoon, go to the courthouse on Friday and file your answer on Friday, because then you can tell them, oh, I'd like to come next Friday, and you know you'll get the morning. If you answer any other day of the week, you will be assigned morning or afternoon at random, and you have no control over it as far as I'm aware. So that's what happens there. Then you come to your first court date. And I think, Lori, why don't you pick it up here as to what someone should do.
Okay, so if you don't have an attorney,
Jenny, I'm sorry.
that's okay. As people say, that's what I get for my mother giving me first name and last name, two first names, first name and last name. So when you get to court on your first appearance date, if you don't have a lawyer, what's going to happen is you check in with the attorney, with the court attorney who works for the judge, go into the courtroom, you'll find your name on the calendar outside, there'll be a number next to your name, you go in and you tell the court attorney, I'm number 43, this is my name, and you check in. And then you'll sit there for sometimes hours, and I'm not exaggerating. And then eventually when the landlord's attorney is ready to talk to you, they'll call out your name, and you'll go out into the hall, and you'll negotiate a settlement of your case. So that's why it's really important to know exactly what your defenses are, what Bruno was talking about before. How much back money do you actually owe? The landlord says you owe $7,000, but you paid most of that. Or your rent is an overcharge, right? Your rent stabilized tenant and your rent is $1,200, but he says it's $1,700, or whatever the issues are. Make sure you know how much rent you owe, and you have proof with you. So you have your receipts, you have your lease, you have any other agreement that you had with the landlord. If you need repairs, you took pictures and you printed those out of the things that are broken, or you have your inspection reports if you had an inspection. If you get to court the first time and you have conditions in your apartment and no proof of it, you should tell the court attorney or the clerk right away, I need an inspection of my apartment, I have bad conditions in my apartment, I want the case adjourned and I want an inspection. They used to give them out in the clerk's office, they don't do it anymore because they have too many requests and not enough inspectors. So, but let's say you're ready to go forward, then you're going to be out in the hall negotiating with the lawyer a settlement of the case. And it'll be written up usually by the landlord's lawyer. If you don't want to discuss this stuff with the landlord's attorney out in the hall, you can ask what's called conference the case. And then you'll be brought into a room with the judge's court attorney, and you'll settle the case in front of the judge's court attorney. There's a little less bullying when you do that. In housing court, you're not allowed to have someone come and speak for you or advise you unless that person's an attorney representing you. It's not like in other kinds of hearings where you can have a friend or a relative come. You're You're not allowed to have someone else speak for you in housing court because it seems to be practicing law without a license. So you have to do it yourself. As I said, it's a really good idea to go to court prepared, have all your documentation with you, and know exactly what you want. And the little green booklet here has a list of the things that you should be asking for. You need repairs in your apartment. Make sure those are written into the stipulation. The stipulation is a written agreement between you and the landlord, signed by the court, basically saying how you're settling the case. Do you owe back rent? How much back rent do you owe? When do you have to pay it? That will be in the agreement as well. And make sure that you can meet the schedule, and if you can't do it, ask the judge or the court attorney for help. Say, the landlord's attorney is bullying me into the settlement. I can't pay $5,000 by next week. That's impossible. I make $2,000 a month. I need more time. So you'll talk about the money, when it has to be paid, and then anything else, like the landlord didn't give you your renewal lease, or, as I said, repairs. You know, are the repairs going to be made? When are they going to be made? You should not sign an agreement that says the landlord's going to come and see if you have problems, and then inspect them, and then repair them if necessary. It should say the landlord's going to come on Thursday, June 16th, and repair the broken tiles in the bathroom. So it should say very specifically what's going to happen on what day. So you agree to all of that, you come to an agreement with the landlord, you sign that agreement, they'll go before the judge will explain it to you, you'll have a chance to ask questions, you should always ask your questions, and then the judge will sign it and give you a copy, and then a binding agreement, and then you leave unless you have to come back to court at a later date.
And when you're in the courthouse, there are places you can seek assistance. There is the table of Jay's organization, the House for Answers, which is located in some public area of
Right, at 111 Center Street, we're right in the clerk's office, and at the Harlem Community Justice Center, we're right outside the courtroom. And in most of the other courts around the city, we're near the clerk's office or on the ground floor.
And each courthouse has something called a resource center, where there are usually one or two attorneys who work for the courts who can give you basic information about how to get. They can't give you legal advice specific to your case, but they can help you navigate the system, give you the proper form you may need for something, help you what answer you should answer, things of that sort. That's a helpful resource also.
111 Center Street.
111.
That's the main Manhattan housing court.
And when you buy there, what is that actually?
Our information table is by organizers. The other thing is all the courts have an officer HRA for human resources that you need to apply for a one-shot deal, which is a loan or a grant from the city to help pay back rent. Also, if you are receiving public assistance or someone in your house is receiving public assistance, they can help you in that office have a case. There are also legal aid and legal services have offices in a lot of legal service providers, I should say, have offices in every housing court in the city now. Legal aid is on the first floor in Manhattan Housing Court, and Northern Manhattan Improvement has an office, I think, on the floor. Yeah. It's all different. The legal services budget was just tripled for the city, so there are a lot of legal service providers.
There's a lot more lawyers available to help low-income people than there were a year and a half ago. So
there's also there's something called the Assigned Counsel for Senior program. So if you're 60 or older and need assistance, you should ask for it. Say, I'm a senior, please steer me to where I can get some help. You can tell the judge that you're a senior and you need help, and the judge can assign counsel to you. And there's also Adult Protective Services in all the courts, and that's a city agency that helps people who are unable to care for themselves. So that could be a mental or physical disability that prevents you from either coming to court or navigating the court. They're supposed to help you, and the court can assign what's called a guardian to that process if you're having trouble navigating the court because of a disability.
So let's break questions now and then we can move on to mobile. Okay, more for this, back there? Yes? Good.
Okay. I'm going to hold over.
Let's save your question until after we finish holdovers. I want to take non-payment. I want to take a lawyer. Always best defense.
For struggling, if you don't have a lawyer and you go before the judge, can you read something that you have written that's not going to take a long time so you don't read anything out?
If it is a trial, the judge will let you testify. You've got a statement you want to make during your testimony. You ask the judge, can I read from a written statement because I haven't got it memorized?
Yes.
And then the judge will let you read from your, as long as it is your own words. If it is like some book or some third party information, the judge will not let you read that because that's called hearsay. That's not usually allowed on the official court record.
It's my own word. That's all next week. And I wanted to make sure I got down dates and times when I started my lease and the scenario of the situation.
Very important information. That's good. Yes, ma'am.
Thank you.
So, our old landlord sold the building at the end of 2014.
Okay.
And so I immediately started to bring my rent down to Union Square, handed it to them, they would sign the date, make a copy, and give it back. So I have all the receipts, but I noticed this year, all of a sudden, they are not showing what a receipt of what I'm paying, and now they're saying I owe $10,000. They haven't brought any court action. I went down there, I've been trying to call BCB management to get an appointment to sit down to go over this ledger that they have, saying I owe $10,000. I have every single receipt. There was some money that I gave the previous landlord. The first rent actually that he can turn over to him, and they're trying to make me pay for that. I have the receipts for that. And I went to her today and she said, well, do we start a court action? I said, no, it hasn't been. So I think there's some violations in my building. But why are they acting like I owe this money?
Because there's often a problem integrating accounting information. An old landlord, accounting information.
That's not my problem, though.
That's not your problem. No, that's absolutely not. That's no, but I'm saying that's how it comes to be. And very often it is not resolved until some non-payment goes to court and the problem gets worked out. What we should do is we should prepare a letter, send it to them by certified mail. Good. So you're protected in case they sue you. And just keep paying your rent each month.
Okay, just keep paying.
Are they sending you rent bills?
Yeah.
And are you paying the amount they're billing?
Yes, and then it would have the balance forward is $10,000.
All right, as long as the bills you receive reflect the payment you've been making each month to this landlord.
No, it's just saying you owe this, I go and I pay it, and then the next month it gets higher, but I haven't paid it.
That you haven't paid in the current month?
Right.
That's definitely right.
They're
That's what
crazy.
happened, yeah.
They're really out of their friggin' mind. I don't know where they're getting this $10,000.
Just send them the same letter by certified mail each month with their rent check.
Are you rent stabilized?
And then tell them, rent stabilized, and then put in your letter, say, if you sue me for this money, I will hire an attorney, and I will seek recovery of my legal fees if I have to go to court to resolve this. That usually wakes somebody up in the office.
I mean, I've gone down there and told them, they keep telling me that it's an accounting problem. And I said, I want these things taken off. I want a zero bill showing what I owe you.
Don't waste your time on it. Just do it in writing. The same letter, just print out the same letter, add the current month's date, just send them the same letter with your rent check every month. You know, unfortunately, you gotta pay the $6 for the certified mail, but protect yourself. Instead, if you go to court, you've got a stack of certified mailings to show a judge. The judge is going to tell them, you better clear up the rent bill right now, and that will be it. Did we answer your question? Yes. No, you were next.
I need to know where to go for the rent.
Downstairs, 5th floor. DHCR.
You need to take with you proof that you live in the apartment and identification, and they should give you a rent history. If they won't give you rent history right on the spot, they'll mail it to you. I'm sorry. 718-739-6400.
That's the number that they gave us yesterday.
They'll mail it to you. I've done it 1,000 times. I promise you it works.
He said, oh, yeah, he was nice enough. I think you were the one that said the call, but you have the person number, right?
Prompts to be confusing people. So what we said at the workshop, it's 1 and 7, but if you get confused or in trouble, whoever gets your phone, say, I want my rent history, get their names in.
But you
How
can
far
get it
back
down
do they go?
in theory to 1984,
Okay.
or when the apartment first entered in the state.
We've got 10 more minutes to cover holdovers. So
Not
let me,
19.
so rather than holdovers, it would be like a whole hour lecture. I'll take any holdover question. Whatever questions, it's just easier than me doing holdovers and having no time for questions. Miss, you had a holdover question.
Yeah, hold over decluttering. What is the best defense?
What kind of holdover?
Clutter.
Clutter? The best defense?
The best
Clean your apartment.
Clean your apartment. Do it yourself.
There are plenty of belongings like that. You have to throw your belongings.
There's only one defense and one way to resolve the case.
Then we
You
apply.
want to do it yourself, because if you don't do it, it's you or somebody else. In this case, it's you. Get everything out. Clean it. I don't care how much you love your stuff. It's like, let me tell you a story. October 29, 2012, Hurricane Sandy, my whole basement, everything I own, gone. To this day, every week I think, where's this? Oh, shit, excuse my language. I lost it in the flood. And I add it to the list of things I've got to buy. You know what? Your belongings, when they're all gone in one split second, you realize you need very little to live. I lived upstairs with clothes and stuff, but you know what? All I needed was my clothes. And I had to buy a new car, and I was fine.
But it's the judge will allow you to be evicted if you do not clean your apartment and keep it clean. And if you need assistance with that, then get assistance somewhere, elected official or whatever. But you
Do it yourself, because if you don't do it yourself, the judge will then refer your case to Adult Protective Services. Adult Protective Services will then meddle in your life. And Adult Protective Services, at the very least, will send you a psychiatrist to your home for a psychiatric exam and the rest. You've been complaining to HPD. I've got somebody now, I've got a case, I'm representing a woman now. Her husband was a tenant of record. He was a rent control tenant, Washington Heights apartment, 3 bedrooms, beautiful views, 5 days, trying to make you move, or trying that would force you to move out of the apartment, or engages in a pattern of activity of suing you. If the landlord keeps suing you for non-payment of rent, and you don't owe the rent just to make you come to court and annoy you, that's harassment under the statute. Okay? But you can't go to Supreme Court and sue the landlord for $1 million for harassing you. The law does not, New York State law does not recognize a cause of action for harassment.
I have all those. They put noise. They put noise in my
We have a
ceiling.
few minutes and we can move on.
And they throw
Yes,
dead
I gotta
rats.
move on.
And then you're next, sir. Okay. And then you're next. Okay, you're next. All right. Everybody gets a minute.
I've been in a housing court,
Yes, sir.
and they actually sued me. I had to pay some. My question is, how much can they go up on me? I went from 4 something to 9 something, and
I would
since
have, okay, I have to know the details of the case. And come here.
Yeah,
From, excuse me, what's that?
yes, 248.
130 to 245.
okay.
So you want from 3.
Are you rent stabilized?
No, it went subsidized.
You're in South Carolina.
Yeah.
All right, I'm not at the table for the rest of the day.
Well, if you want, we have a table out here right by the door. Yeah.
Okay.
Speak to the folks at the house, at the housing court
Mercedes
answer.
is there.
Mercedes,
Okay.
speak to Mercedes.
Good.
One litigation that we have a similar law, and he has five he's four on the dot. I was right after the they're watching us, and they will compete against us.
Be my guest.
In the contemporary world, you can assume,
Everyone is fine.
you can assume there's a camera everywhere. So everything you do, everywhere you go, everything you say, everything you text, and everything you email is somewhere. And if somebody wants to find it, they'll find it. So you know what? The only rule in life today is never say or do anything you're going to want to regret what you say, no matter where you are. Yes, miss.
Hi, I live in a co-op and
Shareholder or renter? Okay.
and we have to fill out an affidavit every year. I received a settlement. I was out of work for 5 years, and I asked them to. It's under the July. I asked them when you lose your job to go down on the rent. They told me they don't do that. So I had to pay what I would pay if I was working. So now I received a settlement, and with that settlement, I had family and friends that sustained me for the 5 years, so I had to give that money back to them. When I put on my affidavit, because where I work at, put the settlement and my salary together. When I put it on the affidavit, they said I have a surcharge. I thought the surcharge was a one-time thing. It's for the whole year, and it's almost $500. And I said to them,
$500 for the year or for each month?
for each month, for a whole year.
Based upon receiving the settlement.
Exactly.
Because they're counting it as income in the year you received it, rather than income spread out over time.
And I showed them exactly what would transpire, and they reassured me it wouldn't be a problem. I received a letter from HPD saying that they're going to charge me 50% and that I would pay. So I wanted to know what my rights are in the reference.
Without the HPD rules in front of you about income and calculation, I don't want to say something that might be incorrect. You certainly should challenge it at the very least. You would probably get a denial letter from the lawyer.
I did get a denial letter.
Did you request a hearing with HPD?
No, what they said to me, because I went down there personally, because I was really upset about it. She said, well, we need to get a letter from everybody that you borrowed money from and bring it to us. But I wanted to talk to an attorney to make sure that that's the step that I should take.
To do that, you should also write a letter to HPD and request a hearing of the issue. While you're collecting that evidence, so you can go before a hearing officer and present your evidence. The notice you got from the housing company should have said, if you disagree with this denial, you have the right to request a hearing.
They said if it's a hardship, then I have to bring proof that it's a hardship.
Bring the proof that it's a hardship.
Which is
You have the letter with you?
Yes, I do.
Oh, yeah. You're doing presentations, but you're going to be around here tomorrow. At the end of your I'm going to give you my card. I want you to email me a copy of the letter. I'll call you back and tell you what.
Okay, thank you.
Yes, miss.
My case is complicated. I want to go into deep. Mine's from a holdover.
Hang on one second. We're supposed to start something called your first use. But is there a whole new 12:30?
Well,
There's a theoretical 15-minute break?
What's 12:30?
So we can go to 12:30. What I'm saying is, if the same people are here from the prior presentation, we can do holdovers and then we can do your first lease. I mean, we don't care. We're here for the duration. Fine. Well, let's check the door at 12:30 and see if there are more people coming in, and then we'll do that topic and then return to this topic. We're here
You had a holdover and it got turned into
We can give me the apartment.
all right. So we're supposed to break down. So for those of you who have
Okay.
Jenny's organization has a table. Feel free to give me a call, shoot me an email, have a question.
If you have evaluations, can you get those on the table?
Excuse me. It was a man. It was a man with. Oh, you work there. You should take it. You're a man.
Yeah, I'll get it. Yeah, thank you. Thank you.
It's on the chair. They said you have to use the same process as the landlord.
I will be here all day tomorrow, one session.
Oh, I got everything.
Your presentation at
I'm just signing that.
She will tell the judge that I'm in here right now. I'm going to have a body like the judge said you don't need to go. I'm going to say the landlord is important with the documentation. And no disabled accommodation while I'm in here. Because she's trying to just override all the laws. And I'm thank you. This is very much interested in all the people trying to all this. I'm just trying to get your question together. We have so many he was moving yesterday. You don't have the first